So I want us to shift our attention to the defenses to defamation. And the first defense to defamation is consent. And sometimes this is called volenti non fit injuria. And the principle behind this defense is that consent is a complete defense where the claimant authorized or agreed to publication of the defamatory material. So that once consent is given, the claimant cannot later claim reputational injury from that particular publication. And here we have the case of Champman versus Lord Ellesmere. And the facts of this case were that the claimant consented to publication of material about himself, which later turned out to be defamatory. And so the issue in this case was whether a claimant who consented to publication can later sue for defamation. And the rule is that consent to publication bars a claim for defamation. And the application of this case was that since the claimant had authorized the publication, he could not later argue reputational harm from the same material. And the conclusion of this case was that the defense of consent actually succeeded. So no defamation claim could proceed. The second defense is offer of amends. And the principle behind this defense is that it is available where defamation is unintentional according to the Defamation Act. And so that the defendant must make the offer, number one, in writing, and then the defendant must publish correction and apology reasonably, and the defendant must pay compensation and costs. And the effect of this particular defense is that if it is accepted, the claimant cannot sue. But if it is rejected, the offer may still operate as a defense. And the case for this particular defense is the case of Newstead versus London Express newspaper, which is a 1940 case. And the facts of this case were that a newspaper wrongfully identified an innocent man as a criminal due to mistaken identity. And the issue was whether an intentional defamation could be remedied through an offer of amends. And the rule was that where defamation is unintentional, the defendant may rely on statutory offer of amends. And the application of this case was that the publication was made without intent to defame the claimant personally. And the conclusion of this case was that the offer of amends defense actually applied. And another case for this defense is the case of Nail versus Newspaper Group, which is a 205 case. And the facts of this case were that false allegations about a well-known actor's sexual history were published. And the defendant offered an apology, but compensation was disputed. And the issue in this case was whether courts can determine compensation after acceptance of apology wording. And the rule in this case was that under the Defamation Act, courts determine compensation where parties agree apology but dispute damages. So the application of this case was that the parties agreed apology wording but disagreed on damages. So the conclusion of the case was that the court assessed compensation under statutory procedure. The third defense to defamation is justification, or sometimes it is called truth. And the principle behind this defense is that truth is a complete defense, so that the defendant must prove that the statement is substantially true, not perfectly accurate, so that minor inaccuracies do not defeat the defense unless they materially damage reputation. And we have a case for this, and it is the case of Alexander versus Northern Eastern Railway Company of 1865. And the facts of this particular case is that a notice stated claimant faced either a £1 fine or 3 weeks imprisonment. And the actual sentence was actually 2 weeks. And so the issue was whether slight factual inaccuracies defeat justification defense. And the rule was that substantial truth is sufficient. The application of this particular case is that the error did not materially affect the seriousness of the allegation. And the conclusion of this case was that the defense of justification succeeded. And I can actually give us an example in illustration. If, for example, defendant proves that the claimant stole, let's say, 1 million Kenyan shillings, which is actually a serious offense, but cannot prove theft of a packet of milk, this defense still succeeds because reputation is already damaged by major allegation. If this justification defense fails, then damages awarded to claimant may be higher. The next defense is what we call absolute privilege. And the principle behind this defense is that it applies where freedom of speech overrides reputational protection, even if statements are false or even if statements are malicious. And the purpose of this particular defense is to protect important constitutional functions. And it applies to parliamentary proceedings, which include speeches in parliament, it includes committee statement, and it also includes Hansard reports. But it does not apply outside parliament. Secondly is where you have judicial proceedings. And these include judges, it includes lawyers, it includes witnesses, it includes tribunals, it includes communication with lawyers, preparing litigation, and it also includes fair and accurate court reports. But this defense is also available for officers of state, and this includes government ministers, but it does not include civil servants like teachers. The fifth defense to defamation is qualified privilege. Now, the principle behind qualified privilege is that it applies where a statement is made without malice, it is honestly believed to be true, and it is pursuant to duty or interest. Now, two limbs must exist for this particular defense. The first limb is where the maker has legal, the maker has moral, the maker has social duty to communicate. And the second limb is where the recipient has corresponding interest in receiving that particular information. And the case for this is the case of Reynolds versus Times Newspaper Limited, 1999. And the facts of this particular case were that a newspaper alleged former Irish Prime Minister misled Parliament but failed to include his explanation. And so the issue was whether political reporting automatically qualifies for privilege. And the rule is that responsible journalism is required to rely on qualified privilege. And the application of this particular case is that failure to include claimant's explanation weakened the defense. The conclusion of this particular case is that qualified privilege defense actually failed. Now, the Reynolds test factors, which include responsible journalism checklist, courts usually consider a number of things. They consider the seriousness of allegation, they consider public importance, they consider reliability of source, they consider verification steps taken, they consider status of information, they consider urgency, they consider whether claimant was conducted, and they consider whether claimant's version was included. They also consider tone of article, and timing and circumstances of publication. However, this is not exhaustive. If you look at the case of Jamil versus Wall Street Journal, Europe 2007, the facts of this particular case were that an article implied claimant funded terrorism. Now, the defendant failed to consult claimant before publication. And the issue was whether failure to meet all Reynolds factors defeat the defense. And the rule was that the Reynolds factors are guidelines. They are not rigid requirements and qualifications. So the application of this particular case was that publication still counted as responsible journalism generally. And the conclusion of this particular case was that qualified privilege defense actually succeeded. Another case for this particular defense is the case of Flood versus Times Newspaper Limited 2010. And the facts of this particular case were that an article accused a police officer of corruption without adequate verification. And the issue was whether insufficient investigation defeats responsible journalism defense. And the rule was that verification steps are essential to qualified privilege. The application of this particular case was that the defendant failed to confirm truth adequately. The conclusion of the case was that qualified privilege defense actually failed. Now, we also have statutory qualified privilege under the Defamation Act, and this one is protected unless made with malice. For example, if you consider Schedule 1, where you have reports of parliamentary proceedings or reports of court proceedings, or Schedule 2, where you have reports of public meetings, for example, councils, companies, and also public bodies. Now, the condition for this is that the claimant must be given an opportunity to respond. The sixth defense is what we call innocent dissemination. Now, the principle behind this particular defense is that it protects distributors who are not authors or editors. And a good example is printers, another example is booksellers and internet hosts sometimes. And the requirement under the Defamation Act is that the defendant must prove a number of things. The defendant must prove that he is not the author, he is not the editor, he is not the publisher, and that he exercised reasonable care and he lacked knowledge of defamation. And a good case for this is the case of Godfrey versus Demon Internet of 2001. And the facts of this particular case was that defamatory statement remained online for 2 weeks after notification. And the issue was whether failure to remove defamatory material defeats the defense. And the rule is that distributor loses defense if aware of defamatory content but fails to act. The application of this particular case is that the ISP knew content existed but failed to remove it. The conclusion of this case is that innocent dissemination defense actually failed. The seventh defense is what we call honest comment. And this was formerly called fair comment. It is recognized in the case of Spiller versus Joseph of 2010. And this one protects freedom of opinion on matters of public interest. And the requirements for this particular defense is, number one, the statement must be comment. Number two, opinion honestly held. Number three, it must relate to public interest, and there must be absence of malice. So let's look at the first requirement. It must be comment and not fact. And here we have the case of British Chiropractic Association versus Sai of 2010. And the facts of this particular case were that an article claimed there was not a jot of evidence supporting treatment promoted by association. And the issue was whether statement was fact or opinion. And the rule was that expression of evaluation of evidence may qualify as opinion. And the application of this particular case was that the Court of Appeal treated the statement as opinion and not a fact. The conclusion of this particular case was that honest comment defense could actually apply. Now, the second requirement when it comes to this defense is honest opinion, so that the opinion must be genuinely believed. In other words, it should not be motivated by spite, so that if it is motivated by spite, then malice is going to defeat this particular defense. The third requirement is public interest, and this includes politics, it includes governance, it includes media, it includes arts, it includes public authorities, and it also includes professional services. So it is a very wide category of defense. So that is all I have as far as the defenses are concerned. But I would like to give you, if you're a student, a quick exam revision summary table for this defense and their key requirements. So the first one was consent. Now, the key requirement as far as consent is concerned is that the claimant agreed to publication. The second defense was offer of amends. And the key requirements as far as offer of amends is concerned is a written apology, is correction, and compensation. The third defense was justification. And the key requirement for justification is that the statement must be substantially true. The fourth defense was absolute privilege. And the key requirements as far as absolute privilege is concerned is parliament, it is courts, and it is ministers. The next defense was qualified privilege. And the key requirements for qualified privilege is duty, interest, and the absence of malice. The next one was innocent dissemination. And the key requirement for innocent dissemination is the distributor is unaware and also reasonable care. The next one was honest comment. And the key requirements were opinion, honest belief, and public interest. So that is all I have as far as the defenses to defamation are concerned. If it is your first time here, make sure you follow this channel and you subscribe so that in our next video, we are going to continue with the next unit as far as tort law is concerned. God bless you and take good care of yourself.